So we've been in the GPS game for a long time. Now GPS has changed dramatically through the years as technology has changed.
No, basically getting in the cement pond during the summer if you have a scram or a GPS device.
Last year we had 44,914 alerts that we dealt with. We're on pace this year so far to have over 66,000 alerts that we monitor and go through.
Well, fantastic Tuesday evening, ladies and gentlemen. We've got a great show lined up for you as we do each and every Tuesday evening from 6 now till 6:30. We're on the new 30-minute format on the Weekly Law Roundup here on WJBZ Praise 96.3. We've got Dan safely ensconced in the traffic-free Chapman Highway Studios while we rest here in the somewhat warm Studio 1924 on Middlebrook Pike. That being said, as you can see, we are also live on Facebook. So, albeit you've always wanted to know what we look like, you're going to be able to see me and my great guest in his Class A's, looking sharp. Got Stoney Gentry from Knox County Probation Pretrial Services, and we're going to be talking a little bit about what programs are going on in Knox County, and so that you guys have a better understanding of what our sheriff's office and what the pretrial programs are operating and how they are working for the better of Knox County. And so welcome to the show, Stoney.
Well, thank you. I'm glad to be here and glad for the invite, and I really appreciate the opportunity.
I tell you, he is a rock star. You know, we had him on several years back, and I know we had a lot of folks that requested basically a repeat. So you were a popular guest, Stoney, and you know, a lot of folks, they hear the term pretrial, and then we hear bond, and we have all the various aspects of that. But kind of explain, if you will, sort of the backbone or the brainchild of Knox County Pretrial Services. How did all of that get started?
Well, Knox County has had pretrial for several years. The first actually started back in the late 70s. And it started with the courts just needing some assistance with individuals that couldn't pay bond, but were more than eligible to make bond. And then it's progressed through the years. And then in the 80s and 90s, it was a point scale system. There was a 15-page interview where every answer had a point score, and then from those scores were either eligible for pretrial release or not. But then, of course, it's still judge discretion, obviously.
Do we see a combination of bail and pretrial where we have not only an amount set for a bond, which we traditionally understand someone goes to a bail bondsman and posts that? Theoretically, they could post it as a cash bond. But that being said, and the utilization of pretrial services as well.
Yeah, so after the initial 15-page interview, then in 2018 we actually revamped pretrial completely. There was major concern with jail overcrowding and housing individuals solely based on financial obligations that they couldn't meet.
Right, we had a lot of people with no affluence that they, you know, not necessarily going to go out and reoffend, but they're just stuck in jail because they couldn't make bail.
That's correct. So we revisited that. We got all the stakeholders together, sheriff, PD's office, DA's office, KPD, the judges, members of the defense bar, all together, and come up with an agreement on what would be scored, and we come up with a matrix. And so pretrial at that point broke into two divisions. We've got our assessments division, which is half of our staff that completely assess everybody that's arrested in Knox County. So as soon as that individual starts the process of the arrest, I have officers 24/7 that monitor those, and through Watson and RMS start assessing those individuals immediately.
Now, you referred to Watson and RMS, so just for the listeners' benefit, tell us what that is.
I completely understand. So Watson is the system that the KPD uses when they're making arrests. It's their computer form. And then RMS is what Knox County Sheriff's Office use. So we monitor those, and as individuals come in, even if it's UTPD, once they are brought into the jail, then we start the assessment process there. They're assessed, and then they're also checked on NCIC, any of the registries like elder abuse or the sex offender, all that information. They're given the score from the assessment that was based, but all that other additional information is composed and concisely given to the magistrate so they can make an informed decision on what type of bond, if possible, or release, if possible.
You know, as far as alternates, as far as monitoring folks, right? So, I mean, you know, we've got scram devices, we got GPS and things of that nature, and, you know, it was kind of, I guess to a certain extent, years ago, you know, we talk about GPS and somebody, it was kind of far-fetched, but now, I mean, it's just a reality, right? We can do that, have exclusion zones, everything of that nature, right?
Oh, yes. So we've actually, our pretrial division's actually done GPS monitoring ever since 2003. So we've been in the GPS game for a long time. Now, GPS has changed dramatically through the years as technology has changed. But new legislation has really amped up the GPS electronic monitoring. New things like 2 years ago, the Debbie and Marie Domestic Violence Protection Act really tied the hands of the judge and made it mandatory for certain charges, crimes against person, to be supervised on GPS, which has greatly increased the number of individuals that we have that are on GPS devices.
You know, we talk about that. I mean, how many GPS devices does Knox County, approximately, I know you may not know down to the exact number because they're always coming and going, but how many GPS devices are out there? And I mean, just, it would seem to me, just the physical monitoring of it, I mean, it's almost like insurmountable.
That's the biggest hurdle we're facing right now, is the amount of work that a case that involves GPS is composed to or compared to those cases without GPS. The best practices recommendations from American Board of Parole and Probation and other sources suggest and strongly recommend that no officer have more than 20 of those cases. However, we have way more than that. So that's the biggest hurdle we're facing right now, is the amount of work that those cases involve. Right now, we currently have roughly 200 individuals that we supervise on GPS, and then we also have 125 that we monitor on alcohol monitoring devices.
It's what we call a scram, right?
Yes. However, there are scram GPSs. We have multiple different types of GPS.
So you could
scram is one of the types
theoretically
of GPS.
wear one on your, so you didn't have to wear two? You didn't have to have one on both angles?
We actually have dual devices on single individuals currently.
Wow. Okay. And I mean, now we'll talk a little bit later about the scram device, but the GPS device, in that, albeit it tells us where the individual is, but ultimately the personal responsibility is the individual's, right? There's nothing that's going to physically stop the person other than the fact that they are under penalty of being punished by the court because they're told not to go into certain zones, correct?
That is correct. So those devices can be set up with exclusion zones, inclusion zones, places they can go or can't go. They can also set schedules, curfews, things of that nature. However, my officers monitor all those alerts, which have grown dramatically due to legislation changes. A few years back, we had 8,000 alerts for the year. Then it went to 16 the following year, 16,000.
16,000 alerts, and how many officers?
Well, there's only 25 of us.
Wow.
Then
we start doing the math and dividing that out, and I mean, you know, you do have to sleep some.
Right.
And these alerts, they come in 24/7, right?
Right. Then we had 36,000 the next year. Last year we had 44,914 alerts that we dealt with. We're on pace this year so far to have over 66,000 alerts that we monitor and go through.
Wow. And how sophisticated is the GPS? If someone has a GPS device on them, I mean, within how many feet? I mean, can you tell basically where someone's at?
Yes. On our system, it actually give a tolerance level depending on how many satellites are locked into that device. It's just like a satellite radio in your car. you'll go through a spot where your radio will go out slightly and then pick right back up. The same process happens with the GPS. There's 16 satellites. As long as you have 3 or more, you've got a good solid feed on that line. The more satellites, obviously, you can narrow that down to a few feet.
As an attorney, in basically trying to facilitate and cooperate with pretrial services, what can we tell our clients to make sure that they make the process smooth for y'all? Because I assume easier is better, and that's what y'all want, right? You want it to be easy for the individual on pretrial services, but likewise easier for the men and women that are supervising.
Well, and you hit the nail on the head. It is simply communicate. Communication can go a long way, especially from the get-go. When you wait too long to communicate, there's already problems that you're going to have to go back and deal with. So simple communication can go a long way, both for not only the officer, but especially the defendant, because the defendant is the one that's ultimately held accountable through the courts for their actions. So simple communication, take time out of their day to ask those questions. And as you well know, there's no dumb question. The only dumb question is the one that gets left unasked that we have to pay for.
You know, we talked about the GPS devices, and obviously those run battery life. How often does the individual have to charge it?
They are instructed to charge it every day, up to 2 hours. 2.5 hours is what it's recommended. However, if you're charging it every day, it will not take up to 2.5 hours to charge.
And you mentioned the SCRAM device, and you mentioned the SCRAM GPS, but let's just, for our purposes today, talk about like the SCRAM and sort of explain kind of how that works. And a lot of times we'll see that used in cases where there's alcohol abuse and substance abuse and things of that nature. Explain sort of when that's implemented and what you see with that.
The majority of those cases are used in DUI offense cases. It's actually an alcohol monitoring bracelet that is fitted to their ankle. It continuously checks their perspiration for indications of alcohol. And then that is downloaded and sent in. It is reviewed, confirmed, and then if there are drinking events, classified drinking events, then the officer is noticed.
So that we sort of assuage people's fears. You know, that you'll hear folks, well, I work as a bartender, or I work in a restaurant as a server and I've spilt a drink. You know, explain how that you can tell with these SCRAM devices the difference between the way that they basically interpret those types of events.
Well, all alcohol is actually is picked up by the device. So even deodorants, lotions, colognes, those things are even picked up by the device. The device is that sensitive. However, all that information has to be confirmed as a drinking event. So events that are a drinking event will actually have a bell curve of the alcohol amount in their system. And you made an excellent example of things that we do here. And a lot of our individuals do work in restaurants or bars where accidents are more than possible. They are likely to happen. But those would not be classified as a drinking event because, yes, at the moment of the spill, it would spike, but the downgrade from the perspiration would quickly eliminate it being classified as a drinking event.
You know, I know that I'm sticky hot walking around out there today, and, you know, I know a lot of our listeners are, and it is that, I guess, long, hot summer. I mean, it is started sticky, nasty hot. But what about that? I mean, are these devices, are they waterproof? I mean, can the person shower? Can they swim? I mean, are they water resistant? What is the, if you will, life with regards to that? Or are they, you know, basically destined to not be able to go in the swimming pool?
Well, they are water resistant. Showers, those things are completely fine. They are required not to submerge the device because we don't want the device to be damaged and use that against them. So it's water resistant but not waterproof.
All right, so you've heard it there from the man. So no basically getting in the cement pond during the summer if you have a SCRAM or a GPS device on you. And I guess there are certain folks, right, that you have the combined, and certain folks that actually have both, right?
That's correct. That's correct.
And, you know, just physically installing it on the individual, I mean, I assume there are special proprietary tools that basically keep someone, I mean, there's nothing you can do. Somebody wants to cut it off, they can cut it off. But as far as the actual physically locking and unlocking?
Yeah, so we've got specialized tools made specifically for the installation and removal of each one of these devices that we use.
Explain a little bit about your officers that you've got, basically as the director of services there, the training that they go through so that they better understand not only how to utilize the devices, but how to make the resources that are available through your office available to the individuals.
Absolutely. So anytime we get a new officer, and a lot depends on what side of pretrial they're on, because we're separated into assessments and supervision. However, through the years, due to necessity, we've had to cross-train and know both sides of that coin. So the assessments officers also deal with on-site after-hours issues where individuals on devices may have to come in to have maintenance or address an issue with their device. But you also have the supervision side, which does the full supervision of the individual and deals with the maintenance devices, the fitting, the removals of those devices. Anytime we have a new officer come in, they are put with other officers, senior officers, to where they all shadow those individuals, and they will first obviously supervise these different aspects of the job, and then they will ultimately be then shadowed themselves by that same superior officer or another senior officer or supervisor to make sure that they have a good grasp on not only the detailed work, the maintenance, the devices, the technical side, but also to make sure that they've got good personal skills, that these are individuals that have not been found guilty of a crime. And so we need to keep that in mind, that these are innocent until proven guilty, and we need to treat them as such. Any of us could find ourselves in a bad situation, and sometimes those bad situations happen to good people. We need to make sure we treat everybody with respect and courtesy, because these are members of our society. They are community members. They're their neighbors. They're the people next door. And a little kindness, a little gentleness can go a long way. Obviously, we are held to a standard to hold these people accountable for the charges they are alleged to commit, but we need to remember both sides.
You know, just as a curiosity question, right? Because I know that you're monitoring the GPS. What's the farthest you've seen somebody go out of quote unquote the zone or Knox County, right? Are they limited to Knox County, or say if somebody's got a job, they're working in Sevierville or something of that nature? I mean, explain a little bit about the parameters with regards to a GPS.
So the device can actually pick up worldwide. We've had people flee the country that...
And they didn't take it off?
I had one individual that was charged with various sex offenses of a minor, and decided to vacate the area after arrest at the border.
A terrible idea as an attorney, just a terrible idea, but it's an even dumber idea to leave the GPS on.
Well, he was under the impression, though, that the GPS only worked in this area in Tennessee. So he thought once he got out of Tennessee that the device was no longer picking up, only to be caught at Border Patrol.
And I assume it was not a pleasant reception for the individual, but
No.
That being said, I have a sign behind my desk, and I know you've seen it. It says, "Can't fix stupid." And, honestly, you can't, but you can give it an IDN number. So that's sort of an inside joke, because I actually have an IDN number, and Stoney does too. If you are in the Justice Information Management System, it is our identification number, but for the most part, when we're referring to an IDN number, it generally is dealing with somebody that's had some sort of involvement with the criminal system. And so our aspect would be from his position in pretrial services and working for the county, and mine as a practicing attorney. But it is kind of an inside joke when we talk about that with regards to that set of circumstances. And from a period of time standpoint, I know you've had folks on. What's the longest that you recall having somebody on pretrial services? Like an individual. I mean, because, a lot of times it takes a long time for a case to kind of migrate through the criminal justice system.
Well, not only the initial progression, but we've also had cases that that went through and was sentenced, and then we immediately got them back on appeal and had to go through that process again. So I've had individuals personally on pretrial for over 8 years.
Wow.
And I had one individual that was on GPS for over 5 years.
It's unreal. Let's talk a little bit more about like what all pretrial services does, because not only are we talking about the day-to-day working with the individuals, but we're likewise talking about the fact that you have to report to the court. And, I know that when I see the warrants laying up there, and ladies and gentlemen, the warrants, they're folded kind of like quad folded, where it is, a lot of outlying counties refer to them as being in shucks, and they're actually in shucks in outlying counties, but it's folded there, and you'll see the pretrial report sticking out. They always come in there and they stick them, and they stick out like about 2 inches so that the judge sees them. And I know some days, it's kind of like Christmas. You don't know whether or not you're getting coal or whether or not you're getting something good. And, I'll pull my client's warrants because despite the assurances that my client tells me that they've done everything that they're supposed to, sometimes I pull that pretrial report out and it's really good news and it confirms everything they've told me, and sometimes I find that they've been less than genuine with me, and then I find myself in a mess, and it's kind of one of those unpleasant surprises. But from that perspective, you got a responsibility to report to the court too, right?
Yeah, so we currently supervise roughly 2,200 defendants on pretrial. Typically, whatever you take our jail numbers, you can add 1,000 to, and that's how many we're currently supervising on pretrial at any given time. So with those individuals, every time that individual goes to court,
there's a new report.
There's a new report. So our officers does a report to the court, and that report, just like you said, goes to the judge, but we also make a copy for the defense attorney. We send a copy to the DA's office. We send a copy to the clerk's office, as well as the judge, because we want total transparency. We want all sides of that argument to be known on how they're doing.
Well, and a credit to the professionalism of Knox County Pretrial Services. This is not just a 1 or 2 line report. It is a sophisticated report. It's typed, it's well prepared, has the information about the defendant, and in fairness, it reports the positives too, i.e. the things that the person has done, if they have certain requirements that they've completed and or done during that period of time, as well as any negatives that might be there.
As well it should. It should be a full, complete report on the individual and how they're doing while they're on pretrial, both the positive and the negative.
We get those reports, and like I said, when I kind of pull that out, I'm like, I'm always really happy when it's a good report, and I'm a little bit chagrined when it's not so good a report. But you're also having your officers, they are called upon to come and testify about their reports on occasion, correct?
Yes. Every day I have an individual or an officer that is on the stand in some courtroom somewhere, and sometimes multiple in the same day. But all of my officers also went through the same process in training. They followed senior officers to testify. I also have very good attorneys that are willing to work with me and my officers, and DAs that are willing to work with my officers, so that way they can hear from each side what questions they can expect, what questions that they may see in the future, and even attorneys and DAs that have even offered to do mock court to give my officers that experience, which is absolutely necessary. Because what they're testifying to has a great deal to the courts.
Well, it makes a difference in the individual's life.
Right.
Whether or not the judge has the ability there when he or she is sitting on the bench to basically revoke that individual's pretrial release, because one of the things that we talk about is, albeit except with certain crimes in the state of Tennessee, that there is a shall with regards to bail and or release. And so you have to understand that's part of the Tennessee state constitution, ladies and gentlemen. But that privilege is not just completely across the board. And when you are given the privilege to be released and to be out there in society, and then you rebuff that privilege and sort of stick your hand up, so to speak, then you have the situation where the officer may have to come in there and testify that you've done this, this, and this. You've been outside of the zones that you're supposed to be in, and or violated and been inside zones you're not supposed to be in, right?
That's absolutely correct. So we want to make sure that we're giving that complete picture to the courts, and that way we got to remember that this is dealing with somebody's freedom.
What about, you're also called upon, I see, the judge will be, can we get somebody from pretrial services over here, called to the courtroom to interview somebody that's out of the jail dock, and or to drug screen folks, right?
Yes.
Because y'all are likewise being called upon to actually conduct urine drug screens as well, right?
That's correct. So all of our officers have been trained in the drug screens, and we also want to make ourselves available to the court to assist, because despite what we may think or how we feel, we are all on the same side. We're all hopefully looking for justice and looking for truth. And so hopefully my officers know that, and I feel they do. I would put my officers up against any other pretrial agency in the state of Tennessee. There is no way that I could do it without them. I have a very solid group behind me. As you well know, the importance of having a good group around you. You're
Absolutely.
only as good as your weakest link.
Well, and seriously, I get nothing out of this, that being said, but the reality of it is Knox County Pretrial Services is second to none. We see them in other counties, and we see them aspire to do what you guys are doing. You're doing a great job, have a fine team, have folks that respond. You can get them on the phone. They are very accommodating with regards to basically telling you what you need. You've got a defendant that needs to go out of town. They're like, if you can get us an order that does this, this, and this, and it's much better to call them, find out the roadmap that they're going to tell you that they need, and then just go get it and comply, and it makes life easier for everybody.
Well, because everything we're acting under is under court order. So if it may seem as simple as, well, I've got a vacation plan and I want to go to another state. However, the court order that was imposed on them may restrict them from leaving the state. So that's where we would need an amended order from the court. It's not that we're trying to be difficult for the defendant. It's that the only way they can leave the state without violating the bond condition is with a new order.
All right. Well, I tell you what, Stoney, thanks for joining us on the Weekly Law Roundup in our new 30-minute format. And want to remind you, ladies and gentlemen, we're going to be here each and every Tuesday evening from 6 to 6:30 here on WJBZ Praise 96.3. You're looking good in the Class A's. I'm serious, man. We're going to make you famous. I don't know. Remember that in Young Guns? It's going to make you famous.
Yeah, you got your close-up over there.
That's good stuff. Hey, rock star.